Contract law. A contract. A contract is a legal binding agreement among two or more parties that is enforceable by the courts. Each party involved in the contract must exchange considerations, which are promises of goods, funds, services, performance, non-performances, etc. A contract can be in written or non-written form. A contract that is made orally is called a parole contract. When a contract is breached, the damages depend on the terms of the contract. Damages are normally monetary, but can also be in the form of performance. Most contracts are enforced by state common law. This includes contracts for employment, real estate, insurance, business contracts, or intangible items. Different types of contracts. Contracts can be express contracts or implied contracts. An express contract is a contract where the elements such as the terms, offer, acceptance, and considerations are specifically stated, as opposed to an implied in fact contract where the elements are assumed. An implied in fact contract is a contract where an agreement between the two parties is assumed simply by the condition. Contracts can also be bilateral or unilateral. A bilateral contract is where both parties have mutually agreed to promise considerations. If Jim promises to cut Tom's yard for $50 and Tom promises to pay Jim $50, then they are both entered into a bilateral contract. A unilateral contract is when only one party makes a promise. An example would be if a radio station offered 2 game tickets to the first caller to answer a question correctly. There is no promise made by the person who wins the tickets. A contract that has been completely fulfilled is considered an executed contract, where a contract that has not yet been filled is called an executory contract. A formal contract is a contract that is legally binding due to the particular form or mode of expression. All other contracts are considered informal contracts. Contracts are governed by contract law, which is a subcategory of common law. Federal and state statutes or programs under statutory law may modify contract law entirely or in part. Although contract law is part of common law, the Uniform Commercial Code has almost completely replaced contract law regarding the sale of goods. The UCC is not law, but is recommendations made to state law. Article 2 of the UCC deals with the sale of goods. If a contract deals with the sale of goods, then one should refer to the UCC. If not, then the parties making the contract will refer to general contract laws as modified by statutory law. Contract requirements. There are certain requirements that must be met for a valid contract. Mutual assent, considerations, legality of objective, and capacity. Mutual assent. To engage in a contract, both parties must show mutual assent. The parties do this by showing words that they have both agreed to enter into a contract. Generally, there is an offer by the offerer of the contract and an acceptance by the offeree of the contract. Considerations. At least one party must exchange promises of goods, funds, services, etc. One party in a unilateral contract or both parties in a bilateral contract. Legality of objective. The contract must not consist of crimes or torts. A contract killing would obviously not be held up in the courts because murder is illegal. Capacity. Parties of a contract must have the legal ability to enter into a contract. A blind man cannot enter into a contract with a mall to monitor the security cameras because he would not have the ability to fulfill his promise or his considerations. Capacity can also be used as a defense in courts. If a party of a contract entered into the contract while intoxicated, he or she may be able to use this as a successful defense. Non-contractual remedies. Non-contractual agreements may be enforced by the courts in the case of a promissory estoppel or a quasi-contract. In contract law, a promissory estoppel is when a person makes a false statement in an attempt to induce another party to act in good faith to his or her disadvantage. The court will treat this as a promise in order to see that justice is served. For example, Jason told Tom that a major television network promised to run a cartoon series that Jason created. Jason asked Tom to write and record music for all the episodes, and in return, he would share the royalties from the television network. Tom wrote and recorded all the music and then found out that Jason was lying and never actually had a contract with the television network. Tom could sue Jason, and the courts would treat his lie as a promise and force Jason to pay Tom a reasonable amount of money for Tom's work. A quasi-contract. A quasi-contract is a non-contractual obligation that is made in order to preserve justice. The requirements for a quasi-contract are as follows. According to the Oklahoma Pattern Jury Instructions, the elements of a quasi-contract are 1. Plaintiff furnished, rendered valuable goods, services to defendant with the reasonable expectation of being compensated. 2. The defendant knowingly accepted the benefits of the goods or services. And 3. The defendant would be unfairly benefited by the services receiving the goods if no compensation were paid to the plaintiff. An example of this would be, if a delivery man accidentally delivered goods to the wrong house and the owner of the house did not notify the delivery man of his mistake even though the owner knew, he could be sued for the value of the goods by the person who the goods were intended for. 1. The homeowner was accidentally rendered goods by someone. 2. The homeowner knew about the mistake and did not notify the delivery man. And 3. The person that the goods were intended for paid for the goods but never received them as he or she was supposed to.